We're live here from Houston, Texas. Every Tuesday, we bring in the immigration updates that you need to know if you are in a non-immigrant visa trying to get the green card on any business immigration visa. Emily, there are the topics that I want to cover today is if a person is on adjustment of status, if they want to change the job, what are the things that they need to do? What is this automatic revalidation? People can enter into United States without having a valid passport visa. I never knew that existed. I just want to know more details about it. I want to also understand that if I were approaching the 6 years of H-1B, and all people know that the limit for the H-1B is 6 years, and if the PERM application has been filed, not approved, what are the alternative things that they have to continue on the H-1B after their 6 years is over? And what's going on in the Washington, D.C. Assembly? Now, the first topic that I want to cover is that I filed my 485 application. I know there is a rule after 180 days that I may be able to change to different company. Can you explain that to me, Emily?
Yeah, so this is under the American Competitiveness in the 21st Century Act, otherwise known as AC-21 or AC-21 portability. It allows you to basically take the green card process with you to a new employer, depending on where you're at in the process, without having to start over and file a new 485 or even a new PERM or I-140. So what are the basic requirements of someone who wants to use AC-21 to take their green card process with them?
They must have filed the 485 application. The 485 application must have been pending for more than 180 days. Then they can change to a different company. When they change to a different company, though, the new company, the job profile should be in the similar profession. It doesn't have to be the same exact job duties. We are not robots who just come and do just mechanized. Every single day, my job differs. Do I just do the same thing, single thing, everything? It differs. But of course, it has to be in the same profession that they need to do. Emily, what if the I-140 is not approved and their 485 is pending? Is it advisable for them to change the job at that time?
I would not advise that, although there's technically a provision that may allow it in certain circumstances. It adds an extra hurdle that you have to cross in order to take that process with you and not end up with a denial of your adjustment of status. At the end of the day, it's all about, the main goal here is to receive the green card so you can move on with your life. And so taking that risk of moving jobs too early when your I-140 is still pending is just not worth the possible downside of getting the adjustment of status.
Yeah, a lot of people advise me asking that, hey, my I-140 is not approved. I'm getting a lot of big job money. Should I change it? I normally tell, look, that all money, we are going to eat it away. And the tension that you're going to go through it's not worth, buddy. It's always advisable to wait until the I-140 is approved now. In circumstances where you cannot stay with your existing company, then I definitely would recommend that you contact a lawyer before you move on to another job. Emily, do people need to stay for 180 days after the I-140 is approved?
The good news there is no. The requirement for 180 days only applies to the I-485 application. So once that's been pending for 180 days, if your I-140 is approved any point after that, you're eligible for AC-21. Now, are there restrictions? You mentioned that the job duties don't have to be exactly the same. What about difference in salary, difference in SOC code, difference in location?
All those things are fine, Emily. Salary difference is fine. SOC code difference, as long as they're in the similar profession. If they're in the software profession, that's fine. But if they want to be a lawyer like me, Microsoft CEO, if they want to flip a burger, definitely no. But if they're in the software profession, they're still in the software profession, that's fine. Most probably, if an immigration lawyer, if I move to a different lawyer, I think so, that's pretty much it. It's still within the same SOC code. Even though I'm just a lawyer, I move from immigration to another thing, that should still be okay. But if they move out of the profession, salary difference also, Emily, I have never seen any 485J getting denied because there is a salary difference between the first job and the other job. Sometimes it's higher, sometimes it's lower. I have never seen any problem in there. Emily, what if the person worked for a future employment? I mean, they never worked for the company. They filed the 485 as if that they're going to be joining that company. Now they changed their mind right now. Can they still file the 485 with the current company?
They can file the 485, and then later after the 180-day mark, if a new job offer comes up, they can still use AC-21 to move to that new job offer, because ultimately this entire process is based on an offer of permanent employment, not actual employment. So as long as at the time of filing the labor certification, I-140 and 485, there's a valid job offer, and you intend to take that job offer when you get your green card, if the circumstances later change and you end up with a different job offer that you want to take, you can definitely do that.
Okay. Emily, on the automatic revalidation, what is this automatic revalidation? People speaking about going to Canada or Mexico and coming back. I moved from F1 to H1B. I don't have the stamping in my passport. I can still go to Mexico, stay there for 1 week and come back, and I still don't need the H1B stamping to come back into the United States?
Yes, in many situations that is possible. It works both if your visa stamp that's in your passport has expired, or if that visa stamp is in a different category than your current immigration status in the US. Basically, when you're coming back into the US, CBP will revalidate your visa and make it valid again for that instant moment when you're entering the US, and pretend that you have a valid visa at that time. So the requirements for automatic revalidation, it's only Canada or Mexico. Your trip has to be less than 30 days, and you cannot apply for a visa. So if you go to Canada or Mexico to actually apply for a visa and are denied or get delayed, you can't then take advantage of automatic revalidation to come back into the US. You also need to have a valid I-94 that is not expired. So the circumstance would be as an F1, you came into the US on F1 and then you change status to H1. Now you have an I-797 approval with an I-94 on it that's still valid for your H1 status, but you don't have an H1 visa. You can still go to Canada or Mexico for less than 30 days, have a vacation, and come back, show your old F1 visa and your new I-797 H1B approval notice with an H1B I-94, and be allowed to enter into the US.
Emily, what is the same scenario? I am on H4 EAD right now. I was on H4 EAD. From October 1st, I got this H1B, but I don't want to continue working for this company. I want to go back to H4. Can I use the automatic revalidation even though I have a 797 approval with H1B?
Yeah, so in that situation, even if your H4 stamp that you entered on has expired, if you do have an H4 approval notice, let's say you came in on H4, filed an H4 extension, got that approved, and then filed the change of status to H1B, you can switch back to H4 by using automatic revalidation using your expired H4 visa stamp and your valid I-797 approval notice for H4, even though you later got another approval notice for H1. You can choose which one you want to re-enter in.
Whoa. I was being told I have to apply from H1 to H4, and you know that it's going to take almost like 8 months to 18 months. Instead of that, I can just go to Cancun, have a margarita, and come back and not pay a lawyer like you?
Exactly. You can pay the resort for a nice stay instead of paying.
Well, what if the next week, now I want to start moving to H1B? Can I go back to Cancun and come back in H1B with a margarita, or do I have to file the change of status?
No, if you've already got that H1B approved, assuming you're coming back to work for that same employer that has the H1B approval notice and your I-94 is not expired, you could absolutely go through automatic revalidation again to come back into H1B.
Have you seen any problem? What do we explain at the time when we come from Mexico to United States with the CBP officials?
No, not at all. I mean, you have a valid I-94 that's unexpired, and you previously entered the US with a valid visa. USCIS authorized that change of status or extension of stay. It's a very clear provision that allows you to travel to only Canada or Mexico.
For those people who have already have a passport stamping in United States, for example, H4 or other thing though, they can go, they don't need any visa for Indian nationals I'm speaking about to go to Mexico and come back. For the people whose passport visa is already expired though, you may be required to get the stamping to go to Mexico to some locations. Some locations maybe you need to check with the travel agency about that. As far as the Canada is concerned, you need to have a stamping to go into Canada. But as far as Mexico, if you already have a US stamping, you don't need anything. You just can go to Mexico. We use that very frequently when people from L1B got their H1B approval. Now they want to move back to L1B, they can do so, and vice versa they can do too. So these are all the things where instead of paying a lawyer getting all these things done, you could do it by going to the outside. We call it as margarita switch. That's the thing. You have a margarita, you can switch. Go and have a margarita again, you can switch again. So it's very easy. We send a lot of people, almost like 3 to 4 people every week. And we don't see any problem in there. Absolutely, we've never seen any problem. Any other questions on top?
Not on that. Next topic is a common situation that's happening right now with PERM processing taking forever, both for the prevailing wage and the actual processing of the application. What do you do if you're approaching your 6-year limit of H-1B time and your PERM is still pending? You need that I-140 to be approved, both the PERM and the I-140, to be able to get your 3-year extension beyond that 6-year limit. What are some of the things that you could do if you run out of H-1B time and your PERM is still pending?
First thing is I would consult a lawyer. There are many different options. Don't go all the way to 5 years and 11 months and 26 days and contact a lawyer, because that's not the right time to contact a lawyer. There are many ways. You can go to Mexico and stay for a couple of stay for 25 days, come back into United States, go back to Mexico, come back to here. So in that way, you all know that when the 6th year has been counted, the amount of time that you spend outside the country is not counted. So if you have a visa stamping, definitely you can go to India and come back. That may be appropriate for you. If you don't have the visa stamping, if you go to India, you may get stuck. The better one is to go to Mexico, spend 25 days, come back. You can keep on extending your time to a time limit where it will either I-140 gets approved or it's been more than 1 year that the labor has been filed. That is one simple thing that people can do. If you have options of going to H4 plus EAD, absolutely, that is the best thing that you can do. You can even just move on to the H4. Now, what about the possibility, Emily, of moving to B1? Can they do that?
I think before an I-140 petition gets filed, they technically should be able to switch to a B1 or B2 for a short-term stay of up to 6 months if they want to remain in the U.S. to visit and stay with family. While they're waiting to be able to switch back to H-1B. The difficulty is the processing times for a change of status to B1, B2, or even a change of status to H4. You may be limited for a while in your ability to come back to H-1B, because that change of status process can take, I don't even know what the current processing time is, probably 12 to 18 months right now, and you're only asking for 6 months or less. It can be problematic to get back to H-1B once you do finally have that I-140 approved. So you may have to travel in order to accomplish that, but it is an option to allow you to stay for a longer period while you're waiting.
Emily, if I am coming very near to 6 years, I leave the country, I stay in India, I get the labor and I-140 approved, can I still apply for beyond 6-year extension without subject to the lottery system?
Yes, that is very clear in the law that you can file for that 7th year extension under AC-21 using an approved I-140, even if you're outside the U.S. You can get the 3-year H-1B approval as long as your priority date is not current. Go for stamping. Hopefully stamping comes back to normal sometime in the near future, and then you come back to the U.S.
Emily, what if I am an Indian national and I file the PERM application, I'm coming near, can I go to India and continue working for the same job?
And if you're an Indian citizen, the laws of India apply to you when you're in India, not the U.S. laws. So there's no restriction on you being able to work for a US employer while you're an Indian citizen in your home country in India. And so we've seen a lot of people that were able to work remotely, especially during all of these COVID delays with the travel bans, with consulates, working remotely from their home country while they wait to return to the US.
So the best way is to plan a little bit earlier, guys, these steps, so that you can get it. Not contact a lawyer at 5 years, 11 months, and 25 days. That's not a right time. It's better to contact well early, at least 6 to 8 months before, so that you can have alternative plan. Of course, don't, labor certification I-140 is definitely, you're working on it, but you need to have a plan B if the I-140 is not approved by the time. I see a lot of question, why is the prevailing wage taking? That's the time it's taking, guys. There is nothing we can do at this point of time. Why it's taking that much long time? PERM labor takes a long time. Why is this lawyers take such a long time to file a PERM? They only take 1 week to file a H-1B. What's wrong with the lawyers?
Nothing. The PERM is the most excruciating process of all of immigration, in my opinion. It takes a lot to make sure it's done properly. There are so many moving parts and different deadlines and different steps that have to be done. One word can ruin an entire application.
But why the length of time is so long?
Well, I mean, the actual recruitment phase of the PERM process has specific time periods where everything has to be done. You can't just do all of your recruitment in 1 week and then file the following week. The job order itself has to be done for 30 days, and then you have to wait another 30 days before you can file. The posting notice, the notice of filing, that has to be done for 10 business days, and then you have to wait 30 days before you can file. So some of these steps can be done in shorter windows, but many of them do have very set requirements, so there's no way you can file a PERM faster than those requirements.
Okay, that's where the problem comes. So when you're filing the PERM, guys, don't be under the belief that, okay, the lawyer took the money, he's going to file it for the company in the next 1 week. That's not going to happen. So please have plan B if you have not had the labor certification approval. I would request that people should file their PERM and I-140 as soon as they enter into H-1B. And absolutely, it's not required that you have to be in H-1B to file a PERM and I-140. We do see a lot of students applying directly from a PERM application. I salute them. I mean, you guys are much well planned. That's a very good plan that on OPT and STEM extension you're doing it. Absolutely, you can do so. So it becomes, once the priority date is earlier, and also you have a lot of advantages. Once it's been more than 6 months after the I-140 is approved, the I-140 practically belongs to you. A lot of advantages. But anyway, if you come very near to 4 years and you haven't done it, I would recommend to contact your company lawyer and also an independent lawyer for you to give a second opinion. What is the plan B if my company doesn't file a PERM application at the proper timing? So you need to have plan A, plan B for it. Otherwise, you will be in trouble. Unless you want to move back to India, then of course, this channel is not going to be much help, because we try to, our focus is more try to keep the people in legal status in the United States. Emily, Washington, D.C., it's a mess. What's going on the budget reconciliation? We have this back and forth ping pong going on the immigration. We have this lady by name Elizabeth, which the Americans call it as parliamentarian, which I don't know, because the English terms that we use, parliamentarian, is a different words than the Americans guys use it, because they're not being this parliamentarian is not elected by the people of the country. That's what the parliament is for. Either directly they are elected or indirectly they are not elected. She's neither directly elected nor indirectly elected. She's appointed by somebody, and you guys call it as parliamentarian, and there is a ping pong going on, and now it looks like she says no for everything, and looks like the elected parliamentarian, which I call it as the vice president, is not been taking charge. And what's going on in the bills?
Yeah, so we really have two major hurdles right now for the reconciliation bill. The first is we need 50 votes to get it to pass, and we have 2 Democratic senators who are dragging their feet on just supporting the bill itself, which, even separate from the immigration side, we have 2 senators that are claiming they're not going to vote for the reconciliation. Now, we've been saying all along, why is reconciliation easier to pass than a regular bill? It's because we don't have to worry about the filibuster that requires a majority vote of 60 to break. Here we just need a simple majority, but now we're struggling even to get a simple majority because of 2 senators. So instead of 1 senator that can cause a filibuster, we have 2 senators that can bring the whole thing down. So that's issue number 1. Supposedly the Biden administration is, meeting with them and trying to work through their problems to figure out how to come up with a compromise to get the reconciliation passed. On the other side is the immigration portion of the reconciliation bill. Plan A was shot down by the parliamentarian. Plan B was shot down by the parliamentarian. Hearing rumors of Plan C being in the works, which may be asking for parole for undocumented immigrants instead of a path to citizenship through the reconciliation. No news about whether this has actually been given to the parliamentarian yet. I've also seen rumors that they actually have 5 different options and they're trying to decide which of the remaining 3 should go forward next to the parliamentarian. So it seems that the Democrats are not giving up on the immigration portions, but their focus is on immigration solutions for the undocumented. That doesn't mean that immigration reform for employment-based is not going to happen. I think the bigger hurdle for them is for the undocumented, and so they're focusing on that. But we need to keep up our pressure and keep contacting your senator's office. Make sure that they include employment-based reforms in whatever happens with the reconciliation bill. On top of that, I was looking today, there are 187 different bills introduced in the House so far.
176?
187 that are immigration.
Immigration?
Yes. Introduced in the House. 7 have passed the House, but the other 180 are just sitting there, no action being taken on them.
That includes the per country bill, that also includes the recent utilization of the unused green cards, especially 80,000 green cards that have been wasted. Of course, that's you're speaking about House. It's also introduced by Senator Tellis of North Carolina in Senate also. But anyway, go ahead, Emily.
Yeah, now in the Senate, we have 90 bills already introduced related to immigration. Not one of them has passed the Senate yet. The only ones that have actually had action taken on them are the 7 that were passed in the House. Those have been started in the Senate and gone to their
Anything related to our
committees.
business immigration in those 7, Emily?
Not particularly. In those 7, it's the Farm Workforce Modernization Act and the American Dream and Promise Act. That's about it that deals with anything related to work visas, but nothing specific to employment-based.
This is not an election year, guys. Next year, that's about 2022 is the election year, because here in United States, for the lower house, which we call it as House of Representatives, every 2 years the election happens. So the election year starts in 2022. So people don't like to do anything in the election year, because if you take a sides, then what happens is that if you take the sides, then people will not like it. That's the reason they don't like to do anything in the election year. Let's go to the question and answers, Emily.
All right. Santosh.
Give me 1 second, guys. Sorry for the audio disturbance. Let's look into more questions, Emily. Should we write multiple letters Congress multiple times? No, Ketki, you should not write multiple letters. You should only write one time, 1 letter though. You can write to the congressman and senator separately. Instead of writing to only senator, please write to the other people too.
Question from Senkit. Spelling on the birth certificate mismatches all other documents by one letter. Is that a problem for the 485? Generally, no. We see that it is quite common. So you can proceed to submit a birth certificate that has a misspelling in the name. We would probably look into the option of also obtaining affidavits from family, friends, or relatives that can confirm what the spelling of your name is. And if USCIS has any questions on that, they will send a request for evidence, giving you an opportunity to explain the discrepancy. But I've never seen an issue with that problem in the 485.
Any update on the Texas Service Center? This is from Tilak Subkota. Texas Service Center is getting better for the applications that have been filed recently, though. But the applications that were being filed in October, they still are dragging their feet. They're getting better, though. Especially with regards to the premium processing updates, they got much better. We are expecting that almost all the premium processing will be accepted in the next in the next 1 month. They will be accepted. That's our prediction.
Srini wants to know, I moved from employer A to employer B, and employer A withdrew my EB2 I-140. Now, if I move back to employer A and that EB2 becomes current, can I use it? Well, you can't use it without taking additional steps. So a withdrawn I-140 is gone. You can't simply file a 485 based on it, but that employer may be able to refile the I-140 using the PERM that supported the previous I-140 filing. The difficulty could be if you were away from that employer for some time, they still have to establish ability to pay for the years that you did not work there. So if their financials don't look good, that I-140 may have difficulty getting approved. So if you're going to do that, you may want to consider filing the I-140 first, make sure that gets approved, and then proceeding to the 485.
Emily, I want to discuss on two main topics. The number one topic is the travel ban, though. Now, we got pretty clear indication from the White House directly that there is a good chance that the travel ban will be lifted in November. They didn't say which part of the November, in November of 2021. Now, they said the people who are vaccinated, but then they haven't did they give any guidance on it?
Yes. So this is, I guess, nothing in writing, but through the American Immigration Lawyers Association, a CDC spokesperson did confirm that the vaccine, in order for it to be considered valid for travel into the U.S., it has to be approved either by the FDA or the World Health Organization. So there is a list on our website, rnlawgroup.com. If you look in our news section, one of our recent articles gives you the list of what those are currently. So you can verify if the vaccine you took is on that list. It's not set in stone. As more different vaccines get approved by the FDA or the WHO, they will continue to add those to the list so other people can qualify in the future.
So, Emily, one of the things that, especially the Indian nationals, so there are two vaccines that they have. One is Covaxin and one is AstraZeneca. No, AstraZeneca is called as what? AstraZeneca is called Covishield. So definitely Covishield is acceptable. This Covaxin, which is prevalent in India, doesn't seem to be on the list though at this point of time. Now this list is not official. Covaxin has not been accepted by WHO at this point of time. So, and the information what we are providing is not official, guys. Looks like AstraZeneca, also called as Covishield, seems to be fine, but we are not sure about Covaxin. Pretty much you guys know that Moderna, Johnson & Johnson, Pfizer should be fine. There's no doubt about it. AstraZeneca seems to be fine, but we are not sure about Covaxin at this point of time.
Shilpi asks, will the EB3 final action date retrogress?
That's the point I was to discuss about.
Yes. So obviously we've said it, I don't know how many times, countless times, that we can't properly predict anything related to priority dates. Is just too difficult. But we do know that Charlie has stated that EB3 could retrogress as soon as November. Now, why would EB3 retrogress when we have all of these extra green cards available? So when I did the math, I think there's 290,000 available this year. So you break that down by category, that comes out to around 89,000 that are available for EB1, 89,000 for EB2, and 89,000 for EB3. Not taking into account any drop down from EB1 to EB2 and any spill across from the rest of the world to the backlogged countries. Basically, what they're saying is of those 89,000 green cards that are available for this year, they already have enough pending applications to use up all of them. So for that reason, they may have to retrogress those EB3 dates, because at the same time, if you remember, when someone has downgraded, they do not consider that person in EB3 until the downgrade is actually approved. Now, we've seen these long processing times of the downgrades at the Texas Service Center. They're rejecting premium upgrades. So we still don't know how many more downgrades there are, and that will definitely impact the ability, what happens with EB3. Because they already know they have 89,000 pending applications, both at Department of State and at USCIS in the EB3 category, and they don't know how many will spill across from the rest of the world.
Emily, there's a couple of things that Charlie has said, and the State Department has indicated that the Congress is moving. Congresswoman Meng's amendment might be approved, which is not approved. So there is the 150,000, which may or may not would have come to the employment base, but now they are in here. So you have 290,000. Last time when we looked into the data though, it's only 270,000 green cards pending. And the processing time is 2 years for these people. So 270,000 pending, and after that there's no data left. And we have 290,000 green cards available. And not to mention that they have adjudicated a lot of applications after the data has been published. Especially in the month of July, August, and September. In the month of June, July, August, and September, they did approve a lot of people. So they might have been flushed out. And these people are taking 2 years. Why are you counting 290? You should also count 140,000 that will be approved next year also into this one, because according to the USCIS, it's taking 2 years. So unless this guy is conspiring to waste the green cards, he should not retrogress at all. In fact, he should move forward. So we would like you guys to put a pressure, contact the congressman. We're going to draft a letter depending on what the priority date and how the priority date will move. We'll give the draft to you once the visa bulletin is out. Because my expectation is that, hey, if you don't have 290 plus 140,000 pending there right now, how are you going to adjudicate them? Because processing time is 2 years, not 1 year. So there should be 290 plus 140, which should be 430,000 applications pending there. But there are no 430,000 applications pending in there. So they should be advancing, not taking back, unless they are conspiring to waste the green cards, just like what they did in 2021, ending on September 30th of 2021. So we will keep watching us, guys. Next week we'll update you on that.
A number of people are asking, you're kind of at the last stage of the process, your I-140 is approved, your biometrics are done, your medicals are done, you've responded to an RFE if there was one. Is there anything you can do to get USCIS to complete the process and approve these cases? Unfortunately, your options are very limited, mainly because the processing times that they've posted, as Raul just said, are 2 years. They won't even let you contact them to put in a service request unless you're outside normal processing time. And the Ombudsman Office just came out with this 2-page tip sheet on how to use the 1-800 customer service number of USCIS. And throughout that 2 pages, they basically say, please don't call us. We're not going to be able to handle your phone call. They just don't have the resources. They're not putting the resources towards customer service at this time. And so you can't call customer service to ask them to help. You can't put in a service request online. The Ombudsman is not doing anything about it because it's still within the normal processing time. Same thing with senators and representatives. They're not able to do anything because it's still within the normal processing time. We've looked into options of litigation. We've stated before, the courts are constantly finding that they don't have the power to cause USCIS to adjudicate adjustment of status applications, or they might say the case should be moved to a different court. They're trying to delay all of these cases. Our hands are tied, unfortunately, for most cases, and it's just a matter of we just have to keep following up and keep watching the processing times.
Srini has this question: concurrently filed AOS and downgrade EB3 application 3 weeks ago, still no receipt notice. How long it takes? You are right, Srini. When the downgrade application is being sent out, especially to the address in Louisville, Texas, which all the normal processings are sent to, because that's the only address you can send to, it is taking about 3.5 to 4 weeks. 4 weeks actually. The cases that we file straight applications, so even if we have sent to the same address, it's taking only 1 week to 10 days. But when we are filing a downgrade application, it's taking a month's time right now to get a receipt notice.
A couple questions on the premium processing for downgrade cases. People are seeing delays in getting the checks cashed or receipt notices issued when you try to upgrade the downgrade to premium processing. And we are experiencing that as well. Still, we're seeing more and more of the premium processing finally getting accepted, but it's sometimes after the third or fourth time of us sending it in. So they are slowly improving, but if you've received a rejection of your premium processing, or it's been several weeks since you submitted it and no update, that is unfortunately normal right now.
Question with regards to Jagannath Kesari and the expiry edition dates of the 485 form. 485 form is officially changing on October 13th. If you are using the old format of it, they will reject it. Now, if the application has been received by the USCIS before October 13th, you can either use the old version of it or the new version of it. But if the application has been received on or after, only new versions will be accepted.
And then from the YouTube, didn't receive the I-539 approval notice. The online status says the post office returned it to USCIS. They contacted USCIS and verified that the address on file is correct. But they're saying there's nothing they can do because USCIS did not receive the approval notice back from the post office. Yes, we do see that happen, and USCIS's answer to that is to file an I-824 application to request a duplicate approval. It is an expensive one, several $100s, and it does take several months to receive it. I will say in one case that I can recall in the not too distant past, I've reached out to the Ombudsman office, and they actually were able to get a duplicate sent because obviously you did everything right. Your address on file was correct, and USCIS should be able to deliver that to you properly. I can't guarantee that would work, and every time you may ultimately have to file that I-824 application to get the duplicate, but it's worth a try.
Ravi Sharma has this question. He has the EB1B file 485. Can he move to a different industry from academic? Ravi, I would definitely consult a lawyer when you're moving from EB1B from one job to another job. When it comes to the EB2 and EB3 though, when people are moving job from A to B, it's more easier compared to that of either EB1A. EB1A is actually more simpler, maybe simpler too, but EB1B is you are an outstanding researcher. There are certain requirements that the new company also need to meet. So definitely consult a lawyer, try to identify the company before when you speak and the job position, and also give them the current job position you have in the job description so that the lawyer can evaluate better when you're moving from company A to company B.
Ramesh has received the GC EAD for himself and his family, but his I-140 is still not approved. He wants to know if he can use that EAD to get his son's social security number and also use it for his spouse's employment. His employer is not willing to do premium processing on that I-140. So yes, for your son, you can absolutely use that EAD in order to apply for the social security number for him if it was not done as part of the I-765 application. For your spouse, if they do use that EAD card, that can be done, but you have to keep in the back of your mind that if that I-140 were to be denied, it's going to cause the 485 to be denied, and your spouse would not have an underlying non-immigrant status to remain in the U.S. She would have to exit, get the new visa stamp based on whatever your non-immigrant visa is, and then come back. So it's not impossible to come back from, but still a little bit of risk when the I-140 is not approved.
A lot of people are asking questions about TV Asia not being live from past 2 weeks. There were some very big technical problems from their side. It's got fixed. We will be there live on Sunday. Sorry about the disturbance, guys. A lot of rumors have been flying about that. Some people are giving bad comments. That's the reason Rahul is upset and not coming. No, we get punched. We're used to it, of the bad comments, and those don't bother us because we have a lot of people that like and give good comments, so we get encouraged. It's just a technical problem, guys. I will be live on next Sunday. Absolutely, I'll be there, and they have cleared all their technical problems. The producer, I spoke with him yesterday also, and they're good and they're all set. We will be there live on next Sunday.
Teja is doing a part-time MBA and wants to know if he changes his job into a management role, can he port the pending 485 to that new job? The short answer is possibly. It does depend really on the specifics of the situation, but there is specific reference to promotions and becoming a manager and how that impacts your ability to use AC-21 portability. And USCIS does recognize that over time, someone may move into a more management role and be actually supervising the people who are in the position you were in previously. And they do recognize that is valid for AC-21 portability purposes. So I think it really depends on the situation. Definitely discuss that with your attorney before you make that change.
Nadesh Shah, is a tax transcript mandatory for I-485? Unable to find I-20s 10-plus-year-old, will that be a problem? I'm assuming that you're speaking about the 485 application of the employment-based. In the employment-based, you do not need the tax transcript to file the 485. This may be, some people may be surprised when I'm saying this, because why not? I mean, you asked us in October of 2020 when we filed the 485. That is right. At that point of time, there is something called 944 form, which we would require your tax transcript. Right now, we do not need tax transcript to file the 485 application. If one or two of your old I-20s are missing, that shouldn't be much of a big problem. You can still file the 485 application without it.
Avanandan wants to know, can the EB-2 filing date progress based on the visa bulletin, as it says it will move by several months? So we do expect EB-2 to keep moving forward every month for several months. But I expect that is referring to the final action date, not the filing date. Historically, when we've had these two charts, which started in 2015, the filing date chart gets set in October, and it generally has not moved throughout the year because it's a prediction of where the final action date should be by September of the next year. Last year was a little bit different. We did see some movement in the EB-2 filing date, maybe January, February. But for the most part, once that filing date is set in October, we don't see a lot of changes in it.
Anurag has this question: what should be mentioned on the interfiling, medical interfiling? Nothing need to be mentioned. Your A number and your file number. When we say file number, that is the receipt notice that you have it for the 485. Remember, when you send the medical in the interfiling, they need to link it to the file, Anurag. They won't know when you say your name is Anurag and whatever your last name might be. I don't want to announce it, but they won't know it. The way that they know is by the A number and the file number. File number is the number that you received. It either starts with SRC or it starts with LIN or MSC. So that will link it though. So when you put that file number, they will link it. You don't have to use, when you're using the word interfiling, what you're telling is that take this thing, put it in the file of my application called 485. How are you telling it's 485? Because you are giving the 485 receipt notice number, also a file number. Some people call it receipt number, some people file number. So that's how they are going to link it and put it to the 485 application.
Our channel wants to know, is it okay to apply for a driving license under AB 60 while waiting for the H4 approvals? I'm assuming you're in California, and the AB 60 is a special kind of driver's license that's meant for people that aren't able to provide proof of their immigration status. I don't see any issue with applying for that. I'm assuming that your old H4 is expired and you're in a period of authorized stay, but you don't have the new I-94 yet because the H4 approval is taking forever. So no issue with applying for the driver's license under that other category.
Sairam has this question. After the biometrics, he calls it fingerprints or biometrics, what do they check background wise? Well, they check whether you have committed any crimes, you have never been arrested at any time, because once your biometrics have been taken based on the eyes by your fingerprints, they can detect if you are a criminal or any unlawful or any bad organizations you are involved in. Emily, in your practice, other than the clients mentioning, have you ever been found anything different? They found anything on the biometrics?
I don't think so.
What's the purpose of it?
Right? Yeah.
Yeah. No, we never found anything in my clients. Very, very, very rarely that ever happens that we get surprised that we find something that we don't know about. But normally, most of our employment-based clients, they're fair, good, paying taxes, nothing to do with any criminal things. Yeah, we do find some DUI sometimes, for sure. Though, then they tell us, and we tell to the USCIS that they had a DUI, and that's not a big issue. I mean, I'm not encouraging it, but it's not a big issue that they will be interviewed, but not much problems with most of the employment-based green cards.
Harry wants to know, if the priority date is current, am I eligible for a 1-year or a 3-year H-1B extension? So once the final action date is current and you're beyond the 6-year limit, from that point you can only get 1-year extensions of your H-1B, and you have to also show that your 485 has been filed within 1 year of when your priority date became current.
How big is the backlog for the consular interviews for employment GCs at Mumbai and Montreal? Absolutely huge. Because of the COVID though, they're not promoting anything right now. So they're really backlogged very seriously on that.
Shilpi wants to know where to submit the I-693. That's the medical exam. Our employer says to wait for the RFE, but our priority date's October 2013, and we don't want to miss the opportunity. So we do have instructions on our website. If you go to rnlawgroup.com and look for medical exam, it'll show you how to do that interfiling as far as where to file it. You have to look at your I-485 receipt notice and see the service center that's there. Also double check that receipt number in the online case status to make sure your case hasn't been moved from one service center to another or from the service center to the field office. If it's still pending at that same service center, send it to the address that's on the 485 receipt notice.
My downgrade is pending and it's not approved I-140, and the priority date is EB2 current. Can I free file the 485 application? At this point of time, we are suggesting people not to. We may change our opinion at a later date, but at this point of time, we're not suggesting. A lot of people are asking with the 2016 priority date, how it's going to move. We'll have to see this November visa bulletin if these people intend to waste the green cards or they intend to utilize the entire 290,000 green cards that are available. If they intend to, though, things should move forward, but if they don't, we may not see much movement. Emily, if things don't work out and this year, that means of 2022, starting from October 1st of 2021, when will the priority date move for these people, for Indian nationals?
You know, I think we're back to our old prediction of, we said 108 years, but it's really 150 years for people to be getting their green cards. Because when you only have 140,000 available and that 7% cap is there, it's just, and you're counting all the dependents. So really for every 3 green cards that are being used, maybe one worker is actually getting the green card out of that 140,000.
So if we don't get this extra 150,000 green cards that have been allocated right now, Indians are going to lose 10 years. 10 years they're going to lose. So it's now or never. So that's the reason we want you guys keep watching, put a pressure on the Congress. That's all we can do. I mean, sometimes things will be beneficial when you try to contact. When we start putting pressure on the State Department, they have commented on our comments. They put a big note saying not to send what we are sending. Also, when it comes to the USCIS, they did improve the adjudication in the last 3 months. The USCIS have put a lot more emphasis on the employment based. They put on the Twitter, they have issued notifications that they are emphasizing and not trying to waste. So we need to keep the pressure. So when the visa bulletin come in, we will draft it. We want you to be aware of it. You need to keep contacting. That's all we can do in this democratic system.
Shakti wants to know, is it a major cost to the new employer if the I-140 is approved and the 485 is pending for more than 180 days? So in this situation, sounds like you're considering using AC-21 to move to the new employer, and the cost to the new employer is practically nothing if you have your EAD, because they don't have to sponsor you at all. You use your EAD that you already have. All they have to do is sign the I-485 Supplement J so that you can submit it to USCIS. Now, whether the company hires their own attorney to do that on your behalf, or they allow you to get that form taken care of and they just sign it, that's up to the company. But the costs of using AC-21 portability versus transferring an H-1B, completely different costs. Much better to use AC-21 if you can.
Shilpi is asking question, should we submit the medicals? My employer is telling to wait for the RFE. Dates may retrogress. What do you tell ours is submitted to the Texas Service Center? I would recommend to contact a doctor that will give you a couple of original medicals, submit one and keep the rest of it just in case if you get a RFE. There are a lot of people who have sent emails to us saying, hi, I got my green card, thank you, you told us to do it, my lawyer told us not to do it, I did it anyway, I got the green card. Yep, we know that the interfiling does work. Not all the time, but it works about 70 to 80% of the time. So if I were you, Shilpi, I mean, these things can go backtrack, who knows? So I would take a shot. I mean, at the most, you definitely will lose some amount of money. But if I were you, I would risk that money in filing the interfiling.
Hero asks, can I change job while my 485 is pending, even though I haven't gotten my EAD and AP approved yet? Possibly. So assuming that your I-140 is approved, your 485 is pending for 180 days, the new job is similar to the one you were sponsored for, you can still use AC-21 to change jobs, but if you don't have your EAD, that means if you're on H-1B, you have to transfer your H-1B to that new employer. So you kind of have 2 separate processes. You need the work authorization through the H-1B, and you use AC-21 and file the Supplement J in order to continue the green card process with that new employer.
Good. Vamshi Krishna got his green card. Good to know. Thank you for letting us know. That's very happy. Please keep us in mind when we are drafting letters. Though you have climbed up, you're out. But please make sure the colleagues who are just climbing up, please help them in writing the letters to the congressmen. We still need those people to be treated equally. We're not telling Indians to be treated anything special. We just want them to be treated equally and in a proper manner. That's all we're requesting. Please continue writing letters, Vamshi.
Raul asks, can I travel back to the USA if I have a valid H-4 stamping, or do I still need an NIE? So if you are traveled to one of the countries that are subject to the COVID ban, you do need an NIE unless you plan on quarantining in another country that is not subject to the ban for 14 days before you travel back to the US.
Emily, now the travel ban is about to be lifted. Any things on the consulate we have seen? We have a court decision that says that they should still issue the visas though.
Yeah, so although the consulates have been told they can't use the travel ban as a reason to not process visa applications or even deny visa applications, You know, we have a lot of people who've not been able to travel for the last year and a half, a lot of people who've been stuck outside the US for the last year and a half. That means there's a huge backlog. The consulates are still not operating fully. They're still only operating on an emergency basis. So I don't expect things to open up drastically and be immediately back to how they were before March of 2020. I think it'll be slow improvement as more and more consulates open up fully.
Anything else, Emily?
I think we're about out of time for today. Thank you all for joining us.
Thank you for tuning in. And don't forget that we do have a live conferences every single day where you can ask questions in the conference call, Zoom conference calls. The link is provided below. Every single day for half an hour, either I or my colleagues will be there. Mostly I will be there. If not, Rebecca Chen, our very good partner in our office, will be there to answer questions every single day for half an hour. The link is provided at the bottom for you guys to ask live questions. Thank you for tuning in.